Hello, this is William Hong Real Estate. In the previous video I talked about the technical aspects of how the real estate lectures and online courses are conducted. I also discussed how the lectures are run, and today I'd like to briefly talk about the contents of the textbook and also give you a short sample lecture. So, if you are interested in real estate, the very first thing you usually do is, first of all, thank you to UBC. You register for courses at the School of Business. Once you register for the course, you'll receive a very thick book, almost the size of a phone book. That book is usually made up of 26 chapters. You study using that book, and along with it, you receive a collection of previous exam questions, often called cheonje. What we cover in our lectures is essentially a condensed version of that thick textbook. So, while the content is the same as the condensed version, I have supplemented it with material that is present in the larger textbook, but only briefly covered in the condensed version. Over time, I have accumulated this additional content and I created my own lecture notes to include it. Many of these points I explained during class, but for topics that are difficult to explain verbally or that I have organized in detail, I have prepared separate lecture notes. For those parts, I plan to cover them specifically using these lecture notes. So if you take a look here for a moment, this is the actual structure. This is an actual page from the condensed version. Today, I plan to briefly give you a preview of Chapter 1 as an introduction to the course. This is the study abroad edition of the book, and then this is the workbook called cheonje. This is the UBCS 2016 version, which is the most recent version, and that's what we'll be using. Actually, as I was preparing for the class, I solved all the first problems in cheonje. So anyway, this is the content related to cheonje. Next, the lecture notes are organized by chapter like this. Mainly, as I was studying, I summarized parts that I found confusing or complicated. Secondly, in this summary note or lecture summary booklet, there are some parts that are either missing or not covered in detail, so I supplemented those by taking content from the main text and reinforcing it. So these notes are used to update content that is either not included in the text we're studying or is a bit out of date. Now, if we start the class, though I feel a bit awkward talking to myself like this. First of all, my impression of real estate is this. From the perspective of those who oversee real estate licenses, it's not good if too many people can attempt it too easily. So they seem to create a bit of a barrier to entry. Usually, you'll notice that the first part is made up of some difficult chapters. Since they start off with law right from the beginning, it's actually a bit challenging for us, since we're not as familiar with Canadian law compared to our own country to discuss Canadian legal matters. Law, when they were young, it might not be a big burden for them, but especially for Koreans like us, we might get a little flustered at first when law or things like that come up. So I suggest creating a slightly difficult part at the beginning and telling those who are going to drop out to do so. I think that is the intention. And now that, even so, for those who continue on, it gets a bit easier in the middle, and then when the mortgage part comes up later, it gets a bit harder again. I think that's how the course is structured. So for today's sample lecture, I'm going to briefly go over the fundamentals of law section in Chapter 1, Real Estate Services. As stated in the textbook, it starts with the story of William the Conqueror. This is briefly mentioned in the main text as well, but there's no need for us to go into detail about the history, and since I'm not a law major myself, I'll only cover what's absolutely necessary for the exam. If there's anything outside of that which I don't know, I'll let you know in advance. So, how does this start? At first, William the Conqueror, who was a Norman Viking, comes into the picture. The Vikings in 1066 or so conquered England. So when he arrived, he saw that at that time everything was set up in the Roman style. Gradually, as he came in, he started to change the system. So that was the initial starting point. And secondly, if you look somewhere in the middle below, you'll see the year 1215. Where does it appear? Around 1215, there was a king named King John the 11th who was quite notorious. What he's famous for is the Magna Carta, which we all know well. The Magna Carta is what we call the Great Charter in Korea. He was forced to sign it here. So up until then, it was I am the state. The king used to rule absolutely, able to do everything as he pleased, an era of absolute monarchy. But after signing the Magna Carta, the Great Charter, it established that even the king could not stand above the law. This became the starting point for the emergence of common law. So whenever we talk about law, this part always comes up. That's how common law was born. In fact, one of the difficulties we face when dealing with real estate law is that in Korea we don't have anything like common law. Here, common law and statutory law are all mixed together, and since both systems still operate side by side, it makes things quite complicated. Especially in the residential sector, when you move toward common law, there are still influential aspects of common law, what we call poison pill clauses, so to speak. You see a lot of these. Anyway, that's how common law began. The third point is that because common law was enforced so strictly, it led to many side effects. So, although it was originally intended for good reasons, because it was enforced so strictly, what is common law after all? It's case law or customary law. Because common law is about following precedents or previous cases exactly as they happened in the past, when a similar situation arises, you have to follow those precedents. But since there are never 100% identical cases, if you apply this too strictly, it can actually cause people to suffer losses or disadvantages, leading to unfair situations. To correct these kinds of injustices or unfairness, people started directly petitioning the king. We had something similar during the Joseon dynasty in Korea, didn't we? Wasn't it called the Sinmungo? This refers to directly submitting petitions to the king, hoping for relief or leniency. As these kinds of situations kept occurring, the concept of equity eventually emerged. That's how the concept of equity law came about. So to summarize and explain after studying this, first, there are common law, equitable law, and statute law. Common law is decisions based on precedent. Precedent means previous cases or examples. So common law is based on precedent, case law, and custom, while equitable law is decisions based on fairness. In other words, to correct the many side effects that arose from the previous system, the king would directly use his authority to say, do this or do that, and this approach came from a perspective of fairness. Then, statute law, as the name suggests, refers to written law, and in other words, it's also called registration. So this came about later when modern society emerged and Parliament began to take the lead. Anyway, the point is that in common law, there's the principle of their decisions. This is probably in Latin, so stare decisis is... that's what it is. Let the formal decision stand. You absolutely need to know what this means. It means to follow precedent, to go according to previous decisions. That's the basic principle. Next, there are two concepts. One is called distinguish, and the other is stare decisis. These are actually opposing concepts. This is the main principle, but if by any chance a problem arises in the area of common law, if following precedent would cause even bigger problems, the judge can, at their own discretion, break from precedent. Breaking precedent and creating a new case law is what happens in that situation. We refer to this as distinguished. And here in the textbook there is a discussion about remedies, specifically the difference between common law and equitable law. This is extremely important. It always appears on the exam. As for exam questions, look at question 805. Or this topic also appears in question 830, so after listening to the lecture, make sure to try solving those questions yourself. First of all, when you sign a contract for something like a house and a breach occurs, there needs to be a remedy. In such cases, under common law, the only available remedy is damages. But this is very limited. However, if you go a bit broader and deeper, remedies like specific performance, injunction, and abatement fall under equitable law. First, the court will try to apply common law, and if that's not enough or seems insufficient, then equitable law can also be brought in to address the issue. Damage, as the word suggests, refers simply to the loss suffered. For example, if you agree to sell a house but the buyer fails to complete the transaction, that causes a problem. So the most common outcome is that the deposit is forfeited. Or if there is a problem with the contract and the house has to be sold at a lower price, that loss would also be considered damage. On the other hand, specific performance means carrying out the original agreement as it was. If you agreed to sell the house, you must sell it. If you agreed to buy, you must buy, regardless of the buyer's situation. Injunction refers to a court-ordered enforcement, which in Korean is translated as court compulsory execution. It means the court orders you to do something or not do something. That concludes today's sample lecture. I ask for the interest and support of everyone preparing for their real estate license. Thank you.